I want to start today's deep dive with a bit of a visualization exercise. It's a little uncomfortable, but stick with me. I want you to picture everything you own.
Oh boy.
Right. The house, the car, that savings account you've been slowly building up, maybe even your grandmother's jewelry or that collection of vintage vinyl records. You've spent a lifetime working for this stuff. You've curated a life.
It's the American dream part of the equation, the accumulation.
Exactly. Now picture this. One day, you're gone. And instantly, all of that stuff, plus the decision of who takes care of your kids if they're young, is handed over to a total stranger who knows absolutely nothing about you, your values, or your family dynamic.
I mean, that is a terrifying image.
Mm.
But according to the stack of research we're looking at today, that is the statistical reality for the majority of people listening to this right now.
Yeah, it's the default setting. And that is the hook that really grabbed me when we started researching this topic. We are looking at estate planning today, which sounds dry, I know, but the source material presents the startling reality. More than half of Americans have absolutely no estate plan in place. Nothing. Zero.
Which is fascinating behavior when you think about it. We insure our cars, we insure our phones, we lock our front doors. We are obsessed with protecting what we have while we are here. But we have a massive blind spot regarding what happens to it when we aren't.
And the question is why? Because I don't think people are lazy. I think they're intimidated.
Oh, absolutely. The barrier to entry is huge. The sources describe the traditional legal system as expensive and complex. You picture a lawyer in a high-rise billing by the 6-minute increment, using words like herein and heretofore.
Right, it feels like a luxury product. If you aren't a Rockefeller, you think, I can't justify spending $3,000 on a stack of paper.
Yeah.
So we procrastinate. We say, I'll do it next year.
But here is the kicker, and this is what we really need to unpack first. If you don't have a plan, the state have one for you. They call it the government plan.
The government plan. It sounds official, maybe even safe.
It is safe in the same way a prison cell is safe. It's secure, but you have no freedom. The sources are actually brutal on this point. They describe the government's default plan as slow, expensive, and completely public.
Let's break those down, because completely public is the one that really stuck with me. I think most people assume that when they die, their financial business is private, like it's a family matter.
That is the biggest misconception out there. If you rely on the government plan, or even if you just have a simple last will and testament, your estate goes through probate.
We hear that word a lot. Probate. What is it, really?
Think of probate as a lawsuit you file against yourself for the benefit of your creditors. It's a quick process. And because it is a court proceeding, everything in it is public record.
Wait, so my assets, my debts, who gets what?
All of it. The source material explicitly warns that a simple will leaves a family exposed because every asset becomes public record. Anyone with an internet connection, your nosy neighbor, a data broker, a scammer, can pull up the docket.
That is incredibly unsettling. And the sources actually mention the consequence of this, right? It's not just about embarrassment.
No, it's about safety. The research highlights that this loss of privacy can attract unwanted attention from outsiders precisely when a family is grieving and vulnerable. Imagine your spouse is trying to plan a funeral, and their phone starts ringing with salespeople or scammers who know exactly how much life insurance just paid out.
That is a nightmare scenario. So that's the public part. What about the slow and expensive part of the government plan?
Well, probate freezes your assets. That's the slow part. The court has to validate everything. The sources mentioned government delays. So your family might need money to pay the mortgage or the electric bill next month, but the accounts are frozen until a judge signs off.
And expensive.
Big money lawyer bills, as the text puts it. Probate often involves statutory fees that come right out of the estate. You are essentially paying the government and lawyers to give your own money to your own family.
There was a story in the source material that really illustrated the flip side of this. Someone who did it right, Steve E. from Virginia.
Yes, Steve's story was a great example of the incapacity aspect, which we often forget.
Right, because estate planning isn't just about dying. Steve's father had used the system we're discussing today to set up a plan. Later, he was diagnosed with Alzheimer's.
And because he had that plan, specifically the powers of attorney and the trust, Steve said the transition was manageable. He didn't have to go to court to get permission to manage his dad's care. And when his father passed, the family could focus on honoring him.
The quote that struck me was that they could honor him properly, rather than fighting a court battle.
Contrast that with the alternative mentioned in the About Us section of the reading. It paints this tragic picture of someone who works a lifetime to build value, only to become, quote, just another public court docket.
Just another public court docket? That really strips the humanity out of it, doesn't it?
It does.
Right.
It reduces your life's work to a case number.
Okay, so we've established the problem. The government plan is a disaster waiting to happen. So what is the solution? Today, we are doing a deep dive into Claim My Legacy estate planning.
Right. And the mission here, based on their materials, is really about democratization.
They use an analogy that I think perfectly frames this: TurboTax.
Yes. Think back 30 years. If
Right.
you wanted to file complex taxes, you had two choices: pay a CPA a lot of money, or suffer through the forms yourself with a calculator and a bottle of aspirin.
And then software came along. It didn't change the tax code, it just changed the interface.
Exactly. Claim My Legacy is applying that same logic to estate planning. The source calls it a revolutionary technology that streamlines the whole process into a simple interview.
Interview is the key word there. I was looking through the description of the interface, and it emphasizes plain English.
Which is huge. The legal industry thrives on legalese. It's a gatekeeping mechanism. The sources call legalese an unneeded barrier. This software strips that away. It doesn't ask you about per stirpus distribution.
It asks, if your first choice isn't there, who do you want to get the money?
Exactly. It's conversational. They even have pop-up help built into the screens to explain terms as you go.
And the speed. The source says you could be printing your plan in about an hour.
That's faster than watching a movie. In 1 hour, you can move from exposed to the government plan to fully protected. No driving to a lawyer's office, no sitting in a lobby reading old magazines.
But I have to play devil's advocate here, because I know what our listeners are thinking. Fast and cheap usually means low quality. If I'm bypassing a lawyer, am I getting a generic, one-size-fits-all form that won't hold up in court?
That is the most important question to ask. And the answer lies in how they built this. The source describes it as an attorney-backed hybrid.
So actual humans were involved.
Very much so. The software engine is the delivery method, but the documents themselves, the templates, the clauses, the legal structure, were drafted by expert estate planning attorneys with decades of experience.
And there's a specific detail about compliance that stood out to me.
The 50-state compliance.
Yeah.
That is critical. Laws in Arizona are different than laws in New York, which are different than laws in Florida. They spent thousands of hours ensuring these documents are compliant in all 50 states.
So essentially, you're getting the intellectual property of a high-end law firm, but you're accessing it through a software interface to keep the cost down.
Precisely. It's the TurboTax model. You aren't paying for the lawyer to type your name. You're paying for the lawyer's expertise that was baked into the code.
So let's open up the hood. What are we actually buying? If I sit down and do this interview, what do I print out? The bundle is called the Comprehensive Estate Plan.
The engine of this whole thing is the Revocable Living Trust.
Why a trust? Why not just a will?
We touched on this with the privacy issue. A will is a set of instructions for the probate court. It guarantees probate. A trust is a vehicle that bypasses the court entirely.
I like the box analogy.
Right. Think of a trust like a treasure chest. You build the chest, and then this is the crucial part. You put your assets inside the chest. You change the title on your house and your bank accounts from John Smith to the John Smith Trust.
And because the trust owns the assets when I die.
The trust doesn't die. The trust just follows the instructions you wrote on the lid. The person you appointed your successor trustee just opens the chest and hands out the assets. No judge, no court, no public record.
But what really impressed me in the source material were the specific features inside the trust. I expected a basic setup, but there are some really sophisticated, almost nerdy options here that usually cost extra with a lawyer.
Oh, absolutely. They've included features that high net worth clients usually ask for. For example, the income-only option.
Okay, let's unpack that, because that sounds like something for the super rich, but it's actually really practical for normal families.
It is. Let's say you want to leave money to your son. That's
Wow.
19 years old and, let's say, impulsive.
He's going to buy a sports car and crash it in a week.
Exactly. If you leave him a lump sum in a simple will, he gets the check and it's gone. With the income-only option in the software, you can structure it so the trust pays him a monthly income, or maybe gets 25% at age 25, another 25% at age 30, and so on.
So you are parenting from the grave?
Benevolent parenting. You're ensuring the money actually lasts. And then connected to that is the spendthrift provision.
I love that term, spendthrift. It sounds like a character from a Dickens novel.
It's an old legal concept, but very powerful. It creates a firewall around the inheritance. It protects the assets from the beneficiary's own creditors.
So if my beneficiary goes bankrupt or gets
Okay.
divorced,
The creditors usually can't raid the trust. That is a level of asset protection you simply do not get with a basic will.
They also mention an AB trust option. Without getting too bogged down in tax law, what is the benefit there?
That is primarily for married couples to maximize their estate tax exemptions. It splits the trust into two buckets after the first spouse dies. Again, this is a strategy that lawyers charge a premium for, and it's built right into the interview flow.
And one more technical detail, the IRA look-through.
Yes, retirement accounts have very specific, very tricky tax rules. If you mess up the beneficiary designation, your heirs could get hit with a massive tax bill immediately. This system includes language to ensure those accounts are handled as tax efficiently as possible.
Okay, so the trust is the big engine, but estate planning isn't just about money, and it isn't just about dying.
No. And I would argue the other documents in this bundle, the ancillary documents, are just as vital. These are about incapacity.
The scenario where I'm still here, but I can't speak for myself.
Exactly. The bundle includes powers of attorney, both financial and healthcare.
Explain the difference.
Financial power of attorney lets someone pay your bills, manage your investments, and handle your taxes if you are in a coma or have dementia. Without this, your family has to go to court to get a conservatorship just to keep the lights on.
Which is another expensive public nightmare.
Exactly. Then you have the healthcare power of attorney and the advanced healthcare directive, sometimes called a living will.
This is the document that tells the doctors what to do about life support.
It does. And I think the value here isn't just legal, it's emotional. By documenting your wishes, yes, I want a ventilator, or no, I do not, you are removing that crushing burden from your family. You aren't forcing your spouse or your children to guess and potentially feel guilty for the rest of their lives.
That is a huge point. It's a gift of clarity.
And finally, there is the pour-over will.
Wait, I thought we were avoiding wills.
You are avoiding using a will as your primary vehicle. But the pour-over will is a safety net. It's a catch-all.
How does it work?
Let's say 10 years from now, you buy a classic car. You're excited, you drive it home, but you forget to title it in the name of your trust. You leave it in your personal name.
I forgot to put it in the treasure chest.
Exactly.
Yeah?
When you die, that car is stranded outside the trust. The pour-over will acts like a funnel. It tells the probate court, hey, this asset was supposed to be in the trust, please pour it over. It might still require a little probate, but it ensures the asset ultimately follows your plan.
It's the backup plan. I want to shift gears slightly and bring in another story from the sources, because we've talked a lot about features, but I want to talk about feelings. Tiffany from Arizona.
Ah, yes. Her testimonial was very moving.
She's a single mom, and her concern wasn't about tax shelters or AB trusts.
No, her fear was much more primal.
She said she was terrified that if something happened to her, her kids would go to foster homes, that the state would decide who raises them.
That is the deepest fear of any parent, especially a single parent.
And she said the affordability of this system, because she couldn't afford a $5,000 retainer, allowed her to finally get a plan in place. She appointed guardians. She said knowing her children would be with the people she chose, not the state, gave her real peace of mind.
That really reframes the whole conversation. We think of estate planning as a financial task. For Tiffany, it was an act of love and protection. It was about safety.
Now, I have to ask the paranoid question. We are talking about typing our social security numbers, our children's names, and our asset values into a website. Is it safe?
It is a totally valid concern. In this day and age, you have to be skeptical. So I looked closely at the security specs provided in the source material. They aren't cutting corners. They use SHA 256 RSA 4096-bit keyed SSL encryption.
Okay, translate that for those of us who didn't major in computer science.
It's bank-level security. Actually, it's often higher than what some regional banks use. The data is encrypted in transit, so while it's moving from your laptop to their server and at rest, while it's stored in their database.
So even if someone hacked the server, they'd just see gibberish.
Essentially, yes. And they didn't just claim this themselves. The source notes that they had an independent analysis done by SSL Labs, and they received an A rating. So they have external validation of their security posture.
That makes me feel better. So practically speaking, how does someone actually get this? I noticed the how to buy section was a little unique. You don't just go to a retail site?
No, it's not typically a direct-to-consumer product like a book you buy on Amazon. The platform is usually licensed to financial professionals, investment advisors, insurance agents, people like that.
So you would get a link from your financial planner.
Exactly. And strategically, that makes a lot of sense. Your financial advisor already knows your assets, your goals, and your family situation. It's logical for them to facilitate the estate plan as part of your holistic financial health.
There is one more feature regarding the business model that I thought was brilliant. The unlimited updates.
This answers the dusty binder problem.
The dusty binder, I can picture it.
In the traditional model, you pay a lawyer, you sign a stack of papers, they put it in a nice binder, and you put it on a shelf. 5 years later, you have another kid, or you get divorced, or the tax laws change.
But to update the binder, you have to call the lawyer and pay another fee.
Right. It creates friction. So people just don't do it. They die with a plan that is 10 years out of date, and an outdated plan can sometimes be worse than no plan at all.
So how does Claim My Legacy fix that?
They use a subscription model. As long as your account is active, you can log in at 2 a.m. and change a beneficiary, remove an asset, or update a guardian. You can print a fresh, updated plan whenever you want.
And the software updates for legal changes automatically?
Yes. If the laws in your state change, the document templates are updated in the background. It keeps the plan living and breathing alongside you.
It really does seem to remove every excuse. We've covered the cost barrier, the complexity barrier, and the maintenance barrier.
That is the conclusion the sources drive us toward. The government plan relies on our inertia. It relies on us doing nothing. This technology removes the friction so we can actually take action.
I want to wrap up by reading a quote from the Wall Street Journal Smart Money magazine that was included in the research stack. I think it cuts through a lot of the noise.
Let's hear it.
It says, if you have some assets, maybe just a car and some nice furniture, or minor children, you still need an estate plan, even if taxes are not an issue.
That really sums it up. We often disqualify ourselves. We think, I'm not rich enough to need a trust. But if you have a life, you have a legacy.
And you have a choice. You can control it, or you can let the state control it.
And that leads me to a final thought I've been mulling over while looking at all this.
Lay it on us.
We talk a lot about legacy in this context. And usually when people say legacy, they mean the money, the inheritance, the house.
The tangible stuff.
Right. But after reading Tiffany's story and Steve's story and seeing how this software is designed, I think we need to redefine that.
How so?
The true legacy isn't the assets. The true legacy is the clarity and the ease you leave behind. When you are gone, your family will be grieving. It will be one of the hardest times of their lives. Do you want their memory of that time to be fighting in a public court, dealing with creditors, and filling out government forms?
No, absolutely not.
Or do you want their memory to be one of peace, knowing you took care of everything, the absence of a mess? That is the greatest gift of all.
That is a powerful way to look at it, the absence of a mess. It's not about being rich. It's about being thoughtful.
Precisely.
Well, on that note, we are going to wrap up this deep dive. Hopefully, we've given you a few things to think about and maybe a little motivation to finally get that plan in place. Thanks for listening.
Thank you. Stay curious and stay prepared.